Hi, I'm Elizabeth Vago. I'm a partner at Spencer West, and I'm going to talk to you today about coronavirus and the impacts on construction contracts. Because of course, coronavirus is pretty big at the moment in the news. So, on the 30th of January 2020, the World Health Organization declared the coronavirus disease outbreak constituted a public health emergency of international concern. It's now spread to more than 25 countries outside of China. So how is this impacting on construction contractors? This can impact in a number of ways. For example, it may cause delays to projects because of material shortages or because of site shutdowns due to government restrictions on the movement of materials and people. So contractors may want to apply for extensions of time or relief from liquidated damages. So if you're a construction contractor, what should you be doing? Well, the first thing to do is to look at the operational provisions of your contract. Many construction contracts require you to submit a revised program if there is a delay to the project. Are you required to serve any early warning notices on the client indicating any possible cost overruns or delays? If so, you must serve those notices promptly, otherwise you may lose your entitlements. And what about progress reports? Are you required to submit progress reports? In any event, you should be keeping records of the impacts of the virus on your project. And if you wish to make a claim, what should you do? Again, you should be looking at your contract and the specific terms of your contract. Now, the coronavirus is likely to fall within the definition of force majeure. But again, it depends on the contract. So the starting point is to look at the definition of force majeure. And often the definition includes events that are outside the reasonable control of either party, allowing the party to suspend performance. And again, the event of force majeure needs to impact your ability to carry out your obligations under the contract. Again, if you want to assert an event of force majeure, you will need to serve a notice on the client and also mitigate the consequences. What if you don't have a force majeure event definition or drafting under your contract? What about frustration? Well, frustration is difficult to show. You must show that you've been hindered from performing or frustrated from performing the contract itself, and you must also show that you haven't drafted for any other supervening events within the contract. So it's a difficult route to go down. If you have an unamended NEC contract, then it may be a compensation event, or if you have an unamended JCT contract, it may be a relevant event, which would entitle you to suspend performance and then ultimately terminate the contract, but it will not allow you to claim any costs entitlements. What about insurances? Well, again, insurances are something to check, but often business interruption insurance will include exclusions for such things as diseases. Again, so notify your insurers and check your insurances in case they respond. So that's it for now, and if you have any questions on this, then please don't hesitate to contact me. My details are on the website. Many thanks.